Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast, Racial Gerrymandering and the 14th Amendment Edition. I'm your host, Bridget Flaherty. On March 18, 2019, the Supreme Court heard argument in Virginia House of Delegates versus Bethune-Hill, a case considering racial gerrymandering claims in the redistricting of Virginia House of Delegates districts. In 2011, the Virginia House of Delegates redrew the 100 Virginia House of Delegates districts. Under the plan, each district was required to have 80,000 residents. Under the 2001 plan, there were 12 districts with the majority black voting age population, BVAP. These districts did not meet the 80,000 resident requirement for the 2011 plan, which meant that any new plan required moving significant numbers of new voters into these districts in order to comply with the principle, one person, one vote. Section 5 of the Voting Rights Act required that any new plan not diminish the number of districts in which minority groups can elect their preferred candidates of choice. To ensure that at least 12 districts remained, the House of Delegates proposed that the 12 majority-minority districts were required to have a minimum 55% BVAP in the 2011 plan. The bill was passed and signed into law. In 2014, registered voters in the 12 majority-minority districts filed suit against the Virginia State Board of Elections, claiming racial gerrymandering in violation of the 14th Amendment. In 2015, the three-judge district court ruled that race was not a predominant factor in the construction of 11 of the 12 challenged districts, but did predominate in one district, District 75, though in that situation, strict scrutiny was satisfied. In 2017, the U.S. Supreme Court affirmed the district court's judgment with respect to District 75, but vacated the judgment as to the other 11 districts and remanded the case, concluding that the district court had relied on a flawed standard when assessing whether race predominated. On remand, the three-judge district court concluded that race predominated in the drawing of all 11 districts and that none satisfied strict scrutiny. The Virginia House of Delegates appealed to the Supreme Court for further review, raising various concerns regarding the district court's predominance and strict scrutiny analyses, as well as evidentiary issues. For their part, the appellees sought dismissal of the appeal for lack of jurisdiction, and the court directed the parties to address whether the House of Delegates lacked standing to bring this appeal. And now, to discuss the case, we have Scott Keller, partner at Baker Botts.
The case is titled Virginia House of Delegates versus Bethune-Hill, and this is the second time that this particular case had reached the Supreme Court after it had been sent back to the lower court by the Supreme Court a few years ago. The main issue in the case concerns the concept of racial gerrymandering in redistricting. The Constitution's Equal Protection Clause has prohibitions about when governments can use race in any government decision-making. At the same time, the Voting Rights Act, through Section 2 and Section 5, which used to apply to some states that needed to get pre-clearance to change into election laws from the federal government, both those provisions of the Voting Rights Act require states to take race into account to some extent when redistricting, at least as far as the Supreme Court has interpreted those provisions. Section 2, the Supreme Court has interpreted, prohibits vote dilution in the sense of a racial minority group must have an opportunity to elect a minority-preferred candidate. Well, that requires states, of course, to account for race when they're drawing lines. And so frequently in these racial gerrymandering cases, that concept of what is racial vote dilution under Section 2 of the Voting Rights Act runs headstrong into the principles under the Equal Protection Clause of the Constitution that states generally should not be accounting for race when making decisions. And that, of course, was front and center in this case. But before I turn to the merits of the racial gerrymandering claims against 11 districts in the Virginia House of Delegates map, there was an initial issue of standing. The quirk here in this case is it was the actual House of Delegates and not necessarily the state of Virginia or the Virginia Attorney General's office that was defending the House of Delegates map by this point. Now, when the case got up to the court the first time around, the House of Delegates was the party defending the map, and the Virginia Attorney General's office had allowed the House of Delegates to intervene and had no problems with the House of Delegates at that time pressing and defending the map before the Supreme Court. Of course, the first time the case came up, the trial court, the district court, the three-judge district court, had upheld the map. So it was the other party asking the Supreme Court for review. Now, at that point in time, there were 12 districts that were being challenged the first time around. And the Supreme Court concluded that one of those 12 was not a racial gerrymander. So it upheld that district. But it sent the other 11 districts back down to the lower court. Now, in that first trial, the trial court found that the lead map drawer, Delegate Jones, was a credible witness. But after remand, there was a retrial. And after the retrial, the three-judge district court found that Delegate Jones was not a credible witness. The second time, the district court invalidated the other remaining 11 districts. So again, the first time around, the district court accepted the testimony from the state's map drawer, upheld the entire plan. After the Supreme Court said one of those 12 districts challenged was valid, but sent the other 11 districts back down for further analysis, then the district court said the state's map drawers were not credible witnesses and invalidated the other 11 districts. And so that was the posture in which the Virginia House of Delegates wanted to defend its maps to the Supreme Court. Now, on that standing point about who gets to represent and defend a state when it wants to adhere to its state redistricting maps, the plaintiff challengers and the United States, the Department of Justice through the Solicitor General, said there was no standing here, that it's up to the Virginia Attorney General's office, and the Virginia Attorney General did not want to pursue defending this plan. Now, of course, the Virginia House of Delegates disagreed, and they said, no, this is affecting our ability as an institution about where delegates come from, who represent what constituencies. And they pointed to a previous Supreme Court decision which found that there was standing when the size of a body was reduced. I believe it was from about 62 to 37 or so members, that there was standing for a legislative body itself and not just the state or the state attorney general's office to challenge that. So much of argument was actually spent arguing that standing question. It's hard to tell from exactly the oral argument transcript, but it does seem like there could be 5 votes at least to find that the House of Delegates does have a palpable concrete injury to have standing. Of course, whether the court would write a narrow opinion on these peculiar facts, particularly that the House of Delegates was allowed to litigate this the first time around, would remain to be seen. And secondly, then moving to the merits issue about the 11 districts still challenged, the main argument from the plaintiffs and the challengers was that for these 11 districts, the state used a 55% black voting age population floor, and it required for all 11 districts that amount of black voting age population. And they said that meant you're using race and you didn't have a good reason to do that. Of course, the House of Delegates said, oh, no, we did. In fact, here, this map passed initially was pre-cleared by the Department of Justice precisely because it maintained enough districts at the requisite level of black voting age population so that it didn't violate Section 5 of the Voting Rights Act, that there wasn't retrogression, that there weren't fewer minority opportunity districts. So from that point, they said, that's a very good reason that we would have had to use race. But even then, they said, we weren't looking at race myopically, and this came up at argument multiple times. One district, for instance, stuck around 60% black voting age population, and the argument there was this 55% floor didn't even come into effect with some of these districts. So how could it possibly have been that race predominated? And the two-step inquiry that the court looks at for these claims is, first, did race predominate, or were traditional redistricting criteria used? And the second step is, even if race did predominate, did the state have a good basis, did it have a strong basis in evidence to believe that the Voting Rights Act or some other reason required it to use race? So in the end, there may be district-by-district differences, or the court may see and agree with actually the United States Solicitor General, who said, even though in his position there was no standing, they said legal error was committed. They said the district court made a legal reversible error by not doing this racial gerrymandering analysis correct. The Chief Justice picked up on the point that I'd alluded to earlier, that the district court here, the first time around, said the map drawer for the state was credible, and the second time was not credible. And the chief asked repeatedly, how do you square that? So these are very unique facts. This could result in a decision that maybe is going to be limited to this unique posture, but at the same time, these racial gerrymandering claims will continue to come up, and indeed the court has seen a few of them in recent terms, and with the next decade census and redistricting just around the corner, you can rest assured that the court will continue to see claims like those raised in the Virginia case.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.